Excellencies, dear colleagues and friends, ladies and gentlemen, all protocol observed, good afternoon. Heartfelt welcome to my second lecture devoted to the reform of international law and the emergence of African statehood. Last week, I have examined how international law of the 19th century, which was European in essence, dealt with African states and peoples. That is, how this European public law has treated Africans, African peoples, and African states. It treated them as mere objects of international law and organized for their subjugation through slavery, slave trade, and colonialism. I showed how Africa and Africans were stigmatized as savage and uncivilized, and how the scientists, the philosophers, the jurists, what we can consider the civil society of the time, how the civil society, this civil society, justified and endorsed the domination and occupation of Africa by European states in the name of their civilized mission. Today, I will examine how African states and peoples have moved from being mere objects of international law to full-fledged subjects and actors in international law. I will show that as the process of subjugation of African peoples, the process of liberation of the African continent was also a collective effort involving both African and non-African players, as well as the civil society at the time. I will further show how newly independent states have then initiated and led the process of reform of international law to ensure that this legal system takes better account of their rights and interests. Indeed, while preparing this second conference, I realized that its title could be read both ways, and that I should do justice to the contribution of African states to the development of international law. Today, I will, in a way, be delivering two conferences combined in one. I will first show how the reform of international law has made possible the emergence of African states on the international scene. I will then show how the emergence of African states on the international scene has in turn contributed to the reform of international law. Today, as at my conference of last week, I have chosen 5 dates relating to events that I consider to be illustrative, very illustrative, of my presentation. The first event, the first date, I would say, is 1919. It's the organization of the Second Pan-African Congress in Paris, France. The second date, I mean, as far as the first date is concerned, I might add, but I didn't put it on the screen, I might add the adoption of the Covenant of the League of Nations in 1919, but I didn't put it on purpose. The second date is 1945. with the adoption of the Charter of the United Nations and the organization of the 6th Pan-African Congress in Manchester, United Kingdom. The third date is the adoption, and the third date, is 1955. The third date is 1955, with the organization of the Bandung Conference in Indonesia. The fourth date, 1958, is the organization in Accra, Ghana, of the first Conference of Independent African States. And last, fifth date, 1960, which marks the adoption of resolution, the landmark resolution 1514, entitled Declaration on the Granting of Independence to Colonial Countries and Peoples. In my lecture of last week, I have notably shown that the process of prohibiting slavery and slave trade was long and laborious, and that even the adoption in 1926 of the Slavery Convention under the auspices of the League of Nations did not put an end to these two inhuman practices. How could it be otherwise when we all know that the Covenant of the League of Nations of 1919 enshrined, albeit implicitly, the dichotomy between uncivilized and civilized nations. Article 22 of the Covenant of the League of Nations indeed established an international regime for, I quote, those colonies and territories which are inhabited by peoples not yet able to stand by themselves under the strenuous conditions of the modern world. Still, according to the same provision, I quote, the well-being and development of such peoples form a sacred trust of civilization. A sacred trust of civilization. And the provision continues by saying that the tutelage of such peoples should be entrusted to advanced nations. End of quote. The administration of the former German and Turkish colonies was thus entrusted to mandatory powers under the supervision of the League of Nations. And three categories were created, namely A, B, and C. The drafters of the Covenant thus failed to enshrine one of the propositions made by the American President, Woodrow Wilson, in his famous 14 points presented before the United States Congress on 8 January 1918. He presented this 14-point, I would recall, as a blueprint for the post-war negotiations, post-First World War peace negotiations. President Wilson indeed pleaded for, I quote, an impartial adjustment of all colonial claims based upon a strict observance of the principle that in determining all such questions of sovereignty, the interests of the populations concerned, the interests of the populations concerned, I repeat, must have equal weight with the equitable claims of the government whose title is to be determined. End of quote. This is point 5 of the 14 points articulated by President Wilson. The drafters of the League of Nations Covenant also totally ignored the appeal made by the participants to the Second Pan-African Congress, which met in Paris in February 1919 on the margin of the same peace conference at which the Covenant was adopted. This is my opportunity here to highlight the role of civil society in the anti-colonial struggle. The Congress, the Pan-African Congress, was indeed organized by militants of Pan-Africanism. Pan-Africanism, which is a political and cultural movement whose main figures were William Bugot Dubois, an Afro-American sociologist, Henry Sylvester Williams, a lawyer from Trinidad, and the Jamaican Marcus Garvey, founder of the Universal Negro Improvement Association, one of the largest mass movements in African history. For a detailed examination of the evolution of Pan-Africanism, I would recommend the reading of the course on Pan-Africanism and International Law that Judge Abdelraoui Yusuf gave in 2012 at the Hague Academy of International Law. This course is also available both in French and English in paperback edition. Judge Yusuf, I recall that Judge Yusuf was the president of the International Court of Justice. He is still a judge, but he was the president of the ICJ. He is also the founder and the president of the African Institute of International Law. And he is also, last but not least, an alumni of the Graduate Institute of International Studies, where he got his PhDs in the early 80s. The Pan-African activists participating in the Paris Congress. The Paris Congress was organized at the same time as the conference, the peace conference in Versailles, nearby Paris. So the Congress adopted a resolution in which the participant to the Congress called on the Allied and associated powers to abolish slavery and corporal punishment, and to grant the natives of Africa the equal right to participate in the government. They also asked the powers to establish, I quote, a code of law for the international protection of the natives of Africa, similar to the proposed international code for labor, end of quote. By proposed international code for labor, they were making reference to the creation, the establishment of the International Labour Organization by the League of Nations, which is part of the Treaty of Versailles. To my knowledge, this proposal made by the Congress, this appeal made by the Congress for the establishment of a code, for the creation of an international code, is the very first formulation of the idea of an international human rights instrument. The rejection by the drafters of the League of Nations Covenant of both President Wilson's proposal and that of the Pan-Africanist movement led the Pan-Africanist movement to focus their demand not only on the respect for individual rights and human dignity, but also and above all on the collective rights of African peoples, mainly the right of African peoples to self-determination. It was thus the 6th Pan-African Congress The Sixth Pan-African Congress, held in Manchester in October 1945, that marked a decisive phase for the Pan-Africanism and in the process of decolonization of the African continent. And this for two reasons in particular. Firstly, most of the participants in the Manchester Congress were from Africa, unlike most of the participants at the previous congresses, who were of African descent, but members of the diaspora from the United States of America or the Caribbean. Three of these African participants went on to become emblematic figures of the Pan-Africanism, of the liberation movements as well, and then became president of their respective countries, namely Nkwame Nkrumah of Ghana, Hastings Banda of Malawi, and Jomo Kenyatta of Kenya. The Manchester Congress of October 1945 marked an important phase in the history of Pan-Africanism, also because it notably called for the rapid decolonization of Africa through the adoption of two declarations. This Congress adopted many resolutions, but two are very important as far as decolonization of the continent is concerned. The first one is entitled Declaration of the Colonial Powers, Declaration to the Colonial Powers, sorry. And the second one, Declaration to the Colonial Peoples. This second declaration to the colonial peoples affirmed, I quote, the right of all colonial peoples to control their own destiny, and declared that, I quote, all colonies must be free from foreign imperialist control, whether political or economic, end of quote. This powerful plea by Pan-Africanist activists for the rapid decolonization of Africa was no surprise, coming only a few months, that is in October, after the adoption of the United Nations Charter in June of the same year, which, as we all know, enshrined the principle of universal respect for human rights for all, without distinction, as well as the principle of equal rights and self-determinations of people. I would just mention, in passing, this proclamation was made, by the Charter, I mean, was made despite the persistence of practices that run counter these principles, namely colonization by France, Great Britain, Portugal, Spain, and the Netherlands, racial segregation in the United States of America, the Gulag in the USSR, and apartheid in South Africa. Coming back to the Manchester Congress. This Congress was actually the last of a series of 6, and also marked the passing of the baton from the civil society to the states in the process of liberation of the continent from the yoke of colonial rule. This handover has, however, been slow. It is indeed worth remembering that at that time, only 4 African states were independent and took part in the drafting and the adoption of the United Nations Charter, which is the most important milestone in the development of modern international law. These 4 African states were Egypt, Ethiopia, Liberia, and the Union of South Africa. All the other African countries were under colonial rule and not subjects of international law. As a result, it was only through the process of decolonization that the influence of African countries could gradually be felt on the development of international law as we know it today. It is, however, with the vigorous support of Asian and Latin American countries that African states have succeeded in reshaping international law and make it more consistent and making it more consistent with the aspirations and interests. In this respect, special mention must be made to the 5 principles of peaceful coexistence put forward by China and India in their agreement of 29 April 1954. Indeed, these 5 principles had a significant influence on the independence of African states and the evolution of international law. 1954 was also important because this Sino-Chinese agreement was made at the same time as the Geneva Accord, which put to an end to the war in Indochina. France lost the battle against the National Liberation Movement of Vietnam. And it was also 1954, as I reminded to you last week, it was the 1st November, it was the start of the Algerian Revolution. So at that time, the colonial empire of France was shaking. The liberation movement fought and won a war against a member of NATO, and this encouraged other liberation movements, and in particular the Algerian liberation movement. So to come back to the 5 principles of peaceful coexistence, I would say that those principles paved the way to the historic Bandung Conference. This conference was held in April 1955 in the capital city of Indonesia. It brought together 29 states from Asia and Africa. There were a small number of African states because there were not lots of African states independent at that time. I will just mention them by name: Egypt, Ethiopia, Gold Coast, Liberia, Libya, Sudan. Those were independent states, and a delegation of the Algerian National Liberation Front representing Algeria, which was still under colonial rule of France at that time. So this Bandung Conference was the first major gathering where countries of the Global South collectively affirmed their solidarity in their fight against colonialism, racial discrimination, and imperial domination. This conference, I think it's important to mention, this conference also led to the creation of the non-aligned movement, which played a prominent role in the reform of international law. 3 years after the Bandung Conference, in 1958, in Accra, Kwame Nkrumah, the president of the newly independent state of Ghana and the main architect of Pan-Africanism, organized the first conference of independent African states, which was attended by the then 8 independent African states, namely Egypt, Ethiopia, Ghana, Libya, Liberia, Morocco, Sudan, and Tunisia. Egypt, Ethiopia, Ghana, Libya, Liberia, Morocco, Sudan, and Tunisia. The Accra Conference declared its full adherence to the principles enunciated at the Bandung Conference and pledged to accelerate the acquisition of the right of African peoples to self-determination. It also agreed that the 8 participating states, members of the United Nations, should act as a group in order to elaborate new norms of international law, taking into account the interests of the newcomers in the international system. In their drive to reform international law, African states have joined forces with Asian and Latin American states and have opted for 2 types of universal legislative procedures. They first opted for the drafting of resolutions through the United Nations General Assembly, such as on the rights of people to political and economic self-determination. They also opted for the promotion of codification conventions in important areas of international law that had previously been governed by customary norms, such as the law of treaties, state succession, or the law of the sea, which didn't take into consideration their interests. I will first say a few words about the right of people to self-determination. This right is indeed, with no doubt, the most important contribution of African states to the development of international law. The process of decolonization indeed brought onto the international scene a large number of new players who, with the strength of their majority, were able to change international law to bring it more into line with their aspirations and interests. African states did not fail to honor their commitments made in Bandung and Accra. Indeed, on the 28th November 1960, at the United Nations General Assembly, 25 African states and 18 Asian members, 25 African states, 18 Asian members, state members of the United Nations, presented a draft declaration, which was adopted 2 weeks later under the title Declaration on the Granting of Independence to Colonial Countries and Peoples. The now celebrated Resolution 1514, adopted by 89 votes, none against, but with 9 abstentions, is today synonymous with the right of colonized people to independence. It solemnly proclaimed, I quote, the necessity of bringing to a speedy and unconditional end colonialism in all its forms and manifestations. It also declared that, I quote, the subjection of peoples to alien subjugation, domination, and exploitation constitutes a denial of fundamental human rights, is contrary to the Charter of the United Nations, and is an impediment to the promotion of world peace and cooperation, end of quote. This landmark resolution also declared that all peoples have the rights to self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. End of quote. Although this resolution was in the form of a non-binding recommendation, its provisions gradually acquired the status of customary international law due to the weight given to this declaration by the main United Nations bodies, and in particular, the International Court of Justice. In many of its rulings, I would name the advisory opinion in Namibia in 1971, the Western Sahara advisory opinion, the East Timor judgment, the advisory opinion relating to the construction of a wall in the occupied Palestinian territory, the advisory opinion relating to the Chagos archipelago, and very recently, the advisory opinion on the legal consequences arising from the policies of Israel in the occupied Palestinian territory. The adoption of this resolution 1514 by the United Nations General Assembly marked a major milestone in the decolonization process initiated by African states. Between 1950 and 1960, that is during a period of 10 years, prior to the adoption of the declaration, some 22 African states and Asian countries, 22 African and 8 African countries achieved independence. Between 1960 and 1965, that is during the 5 years following the adoption of the declaration, 19 other countries followed, 12 from Africa, 2 from Asia, and 5 from other regions of the world. With the strength of their majority, African states, together with other developing countries, were thus progressively able to change international law and to bring it more in line with the aspirations and interests. Still in relation with this principle of self-determination, I would mention that they also were behind the enshrinement of the right to self-determination, economic and political self-determination, in Article 1, common to the 2 covenants of the United Nations on civil and political rights and on economic and social rights. Article 1 of these 2 covenants proclaim as the first, I would say, human rights, the right of people to self-determination. Actually, the enshrinement of this right in the covenant started in early 50s. It was a fight started in the early 50s with the support of the USSR and the Eastern countries at that time. Still in relation with this right to self-determination, another struggle started after the adoption of this 1960s declaration. It was to allow a movement of liberations to use force to liberate themselves from the bond of colonialism. The UN Charter provides only 2 exceptions to the use of force. Use of force is forbidden in international relations, but the 2 exceptions, self-defense and use of force authorized by the Security Council. And at that time, the use of force by national movement liberation was not allowed. So the African states started a new fight to have this endorsed. And this was endorsed finally in Resolution 2625 on the amicable principles between states. And this declaration, this famous declaration, which was adopted in 1970, Resolution 2625, both strengthened the right of people to self-determination. It reaffirmed this right as a principle, and it also allowed national movement to fight against colonial powers and entitled other countries to support the fight of national liberation movement against colonial countries. So it was a very important declaration. It's also a landmark instrument in the history of decolonization. The third push, as far as this right to self-determination is concerned, was made by the African states with their allies here in Geneva, during the negotiation of the protocols to the Geneva Convention. So this time it was not in the field of jus ad bellum, but it was in the field of jus in bello that the African states succeeded to legitimize the recourse to violence by African national liberation movement by equating, I would say, by declaring that national liberation wars are assimilated to international conflicts. Before the adoption of Protocol 1 of the Geneva Convention in 1977, those wars of national liberation were covered by Common Article 3 of the Geneva Convention of 1949. So since 1977, with the adoption of Protocol 1 and Protocol 2, and especially Protocol 1 with Article 1, Paragraph 4 of this Protocol 1 on international armed conflict, the war of national liberation were considered as legal. And the national liberation fighters are to be considered under the protection of this particular additional protocol. So now I'm coming back to, I will examine other fields, other areas where African states have pushed for a reshaping of international law. I have identified 5 other areas. I will go very quickly, namely people's rights to economic self-determination, the law of treaties, state succession in respect of treaties, the law of the sea, and investment law and arbitration. Starting with the people's rights to economic self-determination, I would first mention Resolution 1803 on the permanent sovereignty over natural resources, which was adopted in 1962 by the United Nations General Assembly, and which is also mainly the product of the struggles of African and other global South nations. The adoption of this resolution is important because it led to the proclamation 12 years later, proclamation of a new international economic order. New International Economic Order, an initiative sponsored by Global South countries to create a more equitable and balanced global economic system. The initial impetus to call for a declaration on the establishment of a new international economic order emerged from the adoption of a political declaration at the 4th conference of the non-aligned movement, which was held in Algiers in September 1973. Due to the pressure of Algeria on behalf of the non-aligned movement, a special session of the General Assembly was convened on 8 April of 1974. It was the sixth special session. The initiative of the non-aligned movement reached its apex with the adoption by the General Assembly of 3 legal instruments. The first one is Resolution 3201 on a declaration on the establishment of a new international economic order. The second legal instrument is Resolution 3202 on a program of action to implement the previous resolution. And the third instrument is Resolution 3281 on a charter of economic rights and duties of states. In short, the new international economic order consists of a set of proposals and initiatives aimed at reducing the economic disparities between developed and developing nations and creating a more equitable economic global system by addressing certain numbers of issues, notably fair trade, financial system, resource control, technology transfer, and development assistance. Since 1974, that is 50 years now, African states and their allies from the Global South kept pushing for the adoption of other legal instruments to implement some of the ambitions of this new world economic order. In 2022, for example, the General Assembly adopted a resolution, another resolution on the topic, Resolution 77/174, entitled Towards a New International Economic Order, in which it reaffirmed, I quote, the need to continue working towards a new international economic order based on the principles of equity, sovereign equality, interdependence, common interest, cooperation, and solidarity among all states. This resolution is very long and substantive. I turn now to another important contribution of African states to the development of international law, namely state succession in matters of treaties. The question of state succession in matter of treaties was of particular interest to newly independent African states, given its implication for the actual independence. The clean slate doctrine de la table rase, tabula rasa doctrine, was advocated by the president of Tanzania, Julius Nyerere, in the early 60s. This doctrine was one of the innovative solutions proposed by newly independent African states to address this issue of state succession in the field of treaties. For decolonized countries, which were faced to the obligation to respect treaties that they didn't conclude, that were concluded by former colonial powers. So, in a nutshell, the Nyerere doctrine called for, with regard particularly with bilateral treaties, I will focus on bilateral treaties, the Nyerere doctrine called for the provisional application on a reciprocal basis for a period of 2 years from the date of independence of treaties that were compatible with the sovereign rights of the new states. These 2 years were to serve as a period of reflection during which the new state would decide whether to continue to be bound by these treaties, to renegotiate the treaties with the parties concerned, or to abandon these treaties altogether. This doctrine has been adopted by the African states that became independent after 1962, and also by non-African states as well, such as Barbados, Fiji, or Guyana. The practice of the newly independent African states based on the Nyerere doctrine has been taken into consideration by the International Law Commission, which was then codifying the rules relating to state succession in the field of, in respect of treaties. This doctrine was ultimately enshrined in Article 16 of the 1978 Convention on the Succession of States in respect of treaties, which provide, I invite you to look at the convention, so just because of the time. I am now coming to the law of treaties. In addition to the law relating to state succession in treaty matters, African states have been tackling the issue of unequal treaties or treaties imposed by force, as well as capitulation treaties concluded with certain European states. The African states, therefore, tried to make the most of their influence during the Vienna Convention negotiations. As a result, their concerns were taken into consideration in the Vienna Convention on the law of treaties, notably in relation with the questions of invalidity, termination, and suspension of the operation of treaties. I refer you to Article 52 of the 1956 Convention. which deals with these issues of invalidity and use of force. Of course, the Vienna Convention dealt only with the use of force, violence, but didn't use with the political and economic pressure, which were also some claims by the developing countries to have also the economic pressure, the political pressure taken into consideration as a form of violence, as a form of use of force. I'm coming now to the before last area of international law where the contribution of African states is important, namely the law of the sea and the economic exclusive zone. The newly independent African states have not participated in the drafting of the 1958 and 1960 Law of the Sea Conventions. They were therefore eager to see the legal regime of the seas modified through further international negotiations. Thus, in 1969, 18 African states, together with other developing countries, submitted a proposal to convene a conference to review all the Geneva Conventions on the law of the sea. 3 years later, in 1972, the third United Nations Conference on the Law of the Sea was convened by the United Nations General Assembly, and Kenya proposed the concept of an exclusive economic zone. The main purpose of such a zone was to safeguard the resources and other economic interests of coastal states beyond territorial waters. The outer limit of this exclusive economic zone would be 200 nautical miles, which is about 370 kilometers, with 12 miles, 22 kilometers of territorial sea. Kenya's proposal has been favorably received by the newly independent states of Asia and Africa, and was ultimately accepted by all the participating states of the United Nations Conference on the Law of the Sea. The rules governing the exclusive economic zone were enshrined in the 1982 Convention on the Law of the Sea adopted at Montego Bay, Jamaica, and are now considered as part of customary international law. I'm coming now to the last area of international law where the African states have played an important role in order to improve it, to meet their interest. Investment law and arbitration. One can say, this is my opinion, that African states are moving towards taking control of international investment law through the reshaping of traditional bilateral investment treaties, BITs, through their active role in the discussion within the United Nations Commission of International Trade Law, UNCITRAL, aimed at reforming the investor-state dispute settlement system, ISDS. So they are also trying to reform the investment law through the adoption of the Pan-African Code of Investment. Indeed, the African states were concerned by the dramatic increase in arbitration proceedings against them under Investment Protection Agreement. They have become increasingly cautious about the content of BITs, bilateral investment treaties, concluded with the industrialized countries of the North, from which most of the investors in the continent originate. For a long time, confined to a passive attitude of accepting the rules laid down by the countries of origin of investors, African states have gradually become aware of the need to draw up rules reflecting a balance between, on the one hand, protection of foreign investment, and on the other hand, the protection of their fundamental interests in terms of economic development, respect for environment, protection of human rights, the fight against corruption, and the settlement of disputes, for example. This process of appropriation of foreign investment law has reached an important milestone in 2017. 2017, with the adoption of the Pan-African Investment Code that I just mentioned before, which, although not legally binding, reflects the particular concerns of African states with regard to the regulation of foreign investments and hence the trends emerging on the African continent in the field of international investment law, both in terms of its substantive content, that is, rights and obligations of the parties, and its institutional content, that means with regard to the dispute settlement mechanism. Drafted from the perspective of developing and least developed countries, with a view to promote sustainable development, the Pan-African Investment Codes contains a number of Africa-specific and innovative features, which some are yet unique in investment treaty practice, contributing to fostering Africa's repositioning as a global investment player. One of its most distinguishing features is that it contains a full chapter relating to investor obligations, a full chapter relating to investors' obligations. This first continent-wide model investment treaty, elaborated under the African Union, has influenced the drafting of subsequent bilateral investment treaties and regional investment instruments in Africa. I think it's time for me to conclude. The right of peoples to self-determination is definitely the matrix on which African peoples and states have built their international relations. This cardinal principle of international law has enabled them to emancipate themselves from the colonial domination and, together with other former dependent territories of Asia and Latin America, to elaborate new norms of international law, taking into account their particular needs and interests. In addition to having transformed the norms of international law to their advantage and of the other countries of the Global South, African states have also contributed to securing a more equitable representation of the countries of the Global South within certain United Nations key bodies, such as the Security Council, the International Law Commission, or the International Court of Justice. So African states' contribution consists both in the improvement in the reform of substantive norms, but they also have tackled the issue of institutional reform. So within the Security Council, for example, the number of non-permanent members was raised from 6 to 10 in 1965, granting 5 seats to African states and Asian states altogether. So 5 seats of the non-permanent member seats are today allocated to Asia and Africa. As far as the International Law Commission, the number of members have grew up progressively out of time. There were 15 members in 1947 when the commission was established, 15. This number was raised to 25 in 1961, 25. Then 34 in 1981, 34 members of the International Law Commission. There are currently 9 African members at the ILC. More important is the composition of the International Court of Justice. When the ICJ, the World Court, was established in 1946, there was only one member of the ICJ, the Egyptian Abdulhamid Badawi Pasha. Abdulhamid Badawi Pasha, who, within parentheses, became the first African members of the Institut de Droit International. So this number from 1 grew to 2 in the mid-60s with the appointment, the election of the Nigerian Charles Onyemena and the Senegalese Isaac Foster. From 2, this number grew to 3 in 1970. 3. A Benin judge joined the 2 in 1970, Ignacio Pinto. This number remains to 3 as of today. 3 members for the whole Africa, including North Africa. I would also say that African states have further contributed to the creation of major international institutions such as UNCTAD, United Nations Conference on Trade and Development, in 1964, in the field of economic development. Last but not least, I would mention the initiatives taken by African states to recover the cultural artifacts and works of art removed from Africa as a result of colonization or foreign domination. As, for example, the adoption, the sponsoring first, and the adoption of a resolution to this end by the United Nations General Assembly in 1973. They also pushed for an adoption of a convention to the same end within UNESCO, in convention which was adopted in 1970 on the return of stolen cultural property. I will just say another few words on an important issue. This is the one of reparation. I thought I wouldn't have the time to do that, but I think it's important because I started with this during my last conference. I started with the mention of a resolution adopted by the African Union in early this year. I indeed told you that the African Union has adopted an important resolution on the payment of reparations to Africans for historical crimes, including the transatlantic slave trade and the consequent enslavement of Africans, as well as colonialism, genocide, and apartheid. I didn't tell you that, but I'm telling you now, that next year will be considered, has been declared, next year, 2025, has been declared by the African Union, I quote, justice for Africans and people of African descent through reparations. So this year, as I mentioned last week, is the year of education. Next year will be the year of reparation. So this issue of reparation is very important. I will just draw your attention to one report, an important report, the Brattle report, which was published last year, I think, to which Judge Patrick Robinson, the former Jamaican judge at the International Court of Justice, contributed. So one of the conclusions is that the former colonial countries, and especially the ones who are responsible of slave trade, who have tolerated slavery on their territory, he has identified about 31 countries. He named them slave-holding states, 31 former slave-holding states, and he presented a kind of bill, and this bill is about 107 trillion US dollars. 107 trillion US dollars. There's about $18 trillion only for the United Kingdoms of Great Britain to pay in reparation for slavery and slave trade. So I think that this is another challenge which will be pursued by the African states. It's a very passionate challenge, which is the one to challenge the issue of intertemporal law. It means at that time, slavery and colonization were not only allowed by, encouraged by international law. So the whole issue is now to reverse this and to make these practices forbidden with the retroactive effects, which is another important challenge, as I mentioned just now. And this challenge, the African Union is going to try to pursue it together with CARICOM, the Caribbean states. Yes. So I think it's time for me to thank you for your patience and to invite you to ask questions or make comments if you have any questions or comments to make. Thank you so much. Yes, please.
Do I need to speak into the microphone or anything? No?
Maybe it's, I don't know. Maybe it's better if you speak with. Maybe it's better if you speak with the micro. I think. Hello. Huh?
Thank you, Judge Ouguergouz. I just had a question. I had two questions, actually. The first one on the resolution 2625 on amicable relation between the states that you mentioned, and I wanted to ask the status of this as a norm regarding use of force in relation to the two articles in the UN Charter, as well as a question on investment law and arbitration. And I wanted to ask for your opinion, especially from a perspective from today, where we can potentially and likely argue that capital investment in post-colonial territories does not achieve the purported benefit to the territories being invested in, rather benefiting the former colonial investor states. If you think it is ever possible to decolonize investment law or arbitration, or if that's an oxymoron in and of itself. Thank you.
We'll take 3 questions and then proceed to others.
So my question is about the African states and their official positions with regard to the NIEO, more specifically with regard to the difference of material power and resources among those states that, you know, kind of try to make a distinction between their positions. So we can see, let's say, in the early 70s, in the negotiations for the NIEO, that those third world states with more material powers, more resources, like the oil exporting countries, usually used to take more confrontational positions as opposed to others that were trying to be more conciliatory. So I was wondering to what extent that difference of material resources and at the same time, consequently, the difference of opinions was also clear on a regional basis when they were trying to coordinate their positions with regard to issues of economic nature.
Thank you. Please introduce yourself before asking questions. Another one?
I'm not sure I have understood the question that you were just asked by the gentleman.
Would you repeat, please?
Yes, of course. So I was wondering, we are talking about the African states, we're talking about the third world states, and we sometimes using this unifying category as if like they all had the same positions, kind of a unified voice, while at the same time, when we look at the records of diplomatic negotiations, for instance, for the new international economic order, we see that, those third world states with more material resources, they had a little bit of more difference of opinions, more confrontational views at times compared to other developing countries that were trying to be more conciliatory, more moderate in their views. So I was wondering if the same sort of difference also existed on a regional level when the African states were trying to coordinate their views about international issues of that sort.
Thank you.
Thank you very much.
Aisha, you have a question?
I will start with this issue of investment, actually, which is linked to the question you just asked on the front, united front by the African states. This issue of investment was actually addressed, even the specific issue. Of course, the issue of economic development was addressed by the African states early in the early 50s, in 1958 already, as I mentioned, the Accra conference. At that conference, the African states even mentioned, at that time they were not numerous, as I said, they were only 8. They were already concerned by investment. On one side, they mentioned that they were needing investment, but at the same time, they were cautious about neo-colonialism. And it was the same with the natural resources. So at that time, this issue was already on the table. And the African group, which was created after this conference of Accra, as a unified movement, as a unified front in the United Nations to fight, to defend the interest of Africa, was very much aware of this issue investment. But at that time, since most of the African countries were needy of investment, they were just ignoring the question. They were just ignoring the question, having, as I mentioned in my lecture, a passive attitude. So just accepting leonine contracts, leonine bilateral investment treaties. And it's only recently that they woke up in order to challenge those treaties because they saw that they were not in their interest. And I just mentioned in passing that it's not only the developing countries which are now challenging the BITs, now the developed countries, the countries, the host, not the countries, the developed countries now are hosting investment from the south. And now they are complaining about the ISDS system. So now, as you said, times are changing. So as far as this issue investment is concerned, yes, there's an Africanization movement which started about 5-6 years ago. I mean, it started effectively 5-6 years ago, since the 17th, but the concern were expressed even before. So you had many states in Africa, either individually or through the regional economic communities, who started to challenge some BITs, such, for example, South Africa, who denunciated some BITs with the Netherlands, for example. And the same goes with Tanzania. And other countries are following the move now. And this is the reason why they adopted this Pan-African Investment Code, in order to put the emphasis of their own interest in terms, as I mentioned, in terms of human rights, environment, corporate responsibility, and also in terms of corruption. And they also mentioned that as far as the ISDS is concerned, the settlement of dispute is concerned, that they should prioritize the claim, the recourse to national jurisdiction before going to arbitration. So this is what I wanted to say about this issue of investment and arbitration. Coming now back to you mentioned also something about the resolution 2625. Resolution 2625 is codifying actually international law. It was adopted by consensus It was negotiated during 7 years, so it was already considered at that time as a codification of customary norms of international law, and the norms which were not codified at that time became norms of customary law since the adoption of this declaration 54 years ago. Now, coming back to this issue of the common front, of course, African states have different stage of development. They are endowed with different amount of resources. But when the new international economical order was proclaimed, there was a united front. It was in 1974. It was just after the increase of the oil, the price, which created a turmoil in the world up to 73. And at that time, there was a united front. The movement of non-aligned movement was a non-aligned movement. There was the non-aligned movement, which was unified, and you have the Group of 77, which still exists. But after the collapse of the former USSR, the movement also, I wouldn't say that it collapsed, but it was it's disintegrated in a way. So you don't have this common front that you had in the past. You don't have it, and also there's another issue which came after that, is the issue of climate change and environmental concern. So within the global south, you have a kind of divisions also. You have also, and the division is also along political lines. You know, you have the hardcore countries, which are still hardcore, and you have the others, which are now more or less aligned. So I would say that this is one of the major weaknesses of this push for new reforms. Now they don't have the same. When you speak about the global south, does the global south exist actually? This is a more general question. It's divided. Even within the African Union, you don't have, the African Union itself is also more or less divided on different subject matters. Yes?
Please, yeah, no, please go ahead.
I was going to change the topic completely, so
okay.
Yeah, so maybe you can go first.
Thank you so much. So, Fatsah, thank you so much for the very enlightening discussion and presentation. I have one question having to do with the general topic, and another actually going back to Sohail's question, maybe articulated slightly differently. So the first question has to do with the role of another group of actors. I am sure you know a lot about, but you didn't say much. So your focus was mainly on African states, but what about the role of scholars coming from Africa, or broadly speaking from developing countries? Basically, bringing legitimacy to those claims. It's one thing a state, articulating a claim, but that will always be seen as sort of biased or one-sided. But it's another thing, scholars bringing some, legitimacy to those claims. And we know that there were quite a few of them, Abisab, Bejawi, Anand, Rao, and others. So I would be curious to hear your thoughts. For instance, just one example, they played a major role in showing that General Assembly resolutions, even though technically they were supposed to be recommendations, were not completely devoid of normative significance. And it was an important achievement for African countries. We know that because of the numeric majority developing countries had back then at the General Assembly. The second question, the one going to, and that, by the way, that's something Sohail is writing his PhD on, so hopefully by the time he's done, we will have maybe more, we will know more about that topic. The second question has to do also with the new international economic order. I think Sohail said maybe, there was not as much united front as we tend to assume. I agree that, as you highlighted, with respect to new international economic order, there was a united front at the General Assembly. But what is a little bit more puzzling is exactly on the same topic, at least some African countries were doing bilaterally something completely inconsistent with new international economic order principles. And what I have in mind is specifically standards of compensation. So one major theme in new international economic order movement was that it's for the sovereign state to establish what compensation standard is applicable. I think they were pushing for something like appropriate standard. But bilaterally, they were entering into treaties with global north countries, establishing much higher standard, fair market value, things of that kind. Now that's very puzzling, and there is some literature trying to explain it. I have never been convinced by that literature, but I would be curious to hear your thoughts. So why collectively they were pushing for one agenda, but bilaterally, at least some, and it's not specific to Africa, by the way, it's also happened in Asia and in other developing countries, they were pushing for something radically inconsistent, at least as far as compensation standards were concerned. Thank you.
Thank you very much. Before passing the microphone, I wanted to, to add something regarding this first question about the role of the 12.
Yes.
Because what role the 12 played in the movement in reshaping international law.
That was a pretty long question. Would you like to reply first to this question and then take the next one, or should I?
Yes, maybe.
Yeah.
Maybe. Yes, just to reply to Professor Fouad, the last question concerning the incoherence of the position taken by certain states and defeating maybe the purpose of the claim they were doing collectively with other states. I don't have a particular answer to tell you. I mean, I'm not advising them, so I don't know. Sometimes, states are behaving in a certain way. We always think that states are behaving, they don't have friends, they have only interests. But sometimes it seems that states have more friends than interests. And if I want to comment further, I would say this is particularly the reason why the African Institute of International Law, of which I'm the rector, has been established by Judge Abdullah Yusuf 10 years ago. It's because of this incoherence. I wouldn't say ignorance of states. I'm not talking about African states in particular. But coming back to this issue of investment, bilateral investment treaties, because this is one of the area where states, African states, are not behaving in a coherent way. We're not behaving in a coherent way. We're not behaving in a coherent way. So the idea was to assist African states to negotiate not only BITs, not only bilateral investment treaties or agreement with investors, but also in other fields of international law. So this was the idea, is to assist them in this endeavor. And more states now are coming, asking us to review the arbitration rules or to train their civil servant in order to give them more weapons, to negotiate BITs with investors. Agreement with investors or BITs with foreign states. You might know, Fouad, how those BITs are negotiated most of the time. Developing countries don't have the resources to negotiate them. They pay law firms. They pay foreign law firms to assist them in the drafting. And they are not looking at that time when they sign the BITs, they are not, I would say, they are not cognizant of what they are signing. And they realize what they signed, what they concluded, when they face an arbitration. So this is one of the reasons, I would say. I wouldn't say ignorance, but it's negligence. I would say negligence. And sometimes, of course, this incoherence is voluntary because they align themselves with certain other countries. It's a give and take, you know, negotiation. I give you, okay, I follow you in this negotiation, but you have also to support me in another negotiation. Concerning the role of the doctrine, I think the doctrine is very important, the opinion of legal scholars, whatever side, you know, Professor Muto Emubiala mentioned the theories, third world approach. Those scholars are very important. I wouldn't underestimate their role, but I wouldn't overestimate their role also. You know, at my last, during my last conference, I mentioned the prominent role played by the International Institut de Droit International, International Institute of International Law. We mentioned it in French, actually, Institut de Droit International. It's the role that this institute played in the colonization of Africa. And the institute is also very active now. It has a little bit moved politically, I would say, because of the composition which changed. Composition changed. So the institute is also now producing resolutions and work in certain fields which are of interest of African states, of developing countries. In the field, for example, of intellectual property, access to medications in particular. And we have now two commissions devoted to social justice or international justice. So those, I think it's important to have scholars thinking and fueling the governments and encouraging them. But at the end, even though it's considered as an auxiliary source of international law by Article 38 of the Statute of the International Court of Justice, I wouldn't overestimate the importance of the opinion of these legal scholars. You were asking another question. Fuad, did I reply to your question?
Yes, yeah.
Yes?
Perfectly, yeah.
Please.
Great, thank you. I'll ask my question very quickly. Thank you very much. First-year PhD student. I was wondering, so you spoke about the African influence on this right to self-determination. I was wondering, has there been any discussion within the Pan-African movement on the notion of people as a legal category, as holders of the right to self-determination?
Sorry, discussion within what?
This Pan-African movement that you were describing, on this notion of people as holders, a legal category that can hold the right to self-determination.
Actually, the discussion ended in 1945. As far as Pan-Africanism, civil society, when I say Pan-Africanism, it's the civil society at that time, which were at the origin of Pan-Africanism. And this Congress, this 1945 Congress, was the last one, was the very last one. And the idea of the activists at that time was to bring to independence African states. They were not thinking, because now you are making reference to peoples within a state, people within a state. So at that time, the priority was to get independence, to be unified in order to get countries and peoples within certain territories in Africa becoming independent. And this was, of course, a concern after the independence of states, you know, after 1962. This will be the topic, actually, of my two next lectures, this issue of peoples within a state. But in a nutshell, I would say that there was a big, a slow movement, a slow development of the issue. And this was discussed, of course, among scholars. There are lots of literature, the importance of the legal doctrine on this issue of self-determination of people integrated within an African state, which is a particular and very important and sensitive issue in Africa because of the borders which were inherited from colonialism, from colonization. You have lots of states, lots of people who were divided between states. And within the same state, you have many communities. You can name them peoples, ethnic group, tribes, whatever. So you have many entities which can be named peoples. I'm just talking about Africa now. So there was a very slow movement, which actually culminated in 1981 with the adoption of the African Charter on Human and People's Rights. African Charter on Human and People's Rights. So when this charter was adopted, people were, the doctrine, the legal scholars, but also NGOs, international NGOs like Amnesty International, Interrights, were questioning this charter, saying, what is this African Charter on Human Rights? We can understand, but what about people's rights? Peoples can only be states. So this charter takes with one hand what it gives with the other hand. So the charter was very much criticized at that time. But talking today, you have the African Commission of Human and People's Rights. You have the African Court of Human and People's Rights telling you that an entity within an independent African state can be considered as a people. In other words, an ethnic group within a state can be considered as a people. So now there's a kind of consensus, I would say, I wouldn't say political consensus, but judicial and quasi-judicial consensus to say that the people within the state is entitled to the rights provided by the African Charter. The African Charter is providing for certain numbers of people's rights, about 6. But there's a but. The but is right of people to political self-determination in the external dimension. So you can be considered as a people. You can benefit all the rights provided by the African Charter, right to economical development, right to development, right to security, right to environment. But as far as the right to self-determination is concerned, I'm speaking now in my own capacity because this case has not been yet put forward before the African Commission or the African Court. It was put forward once. I will come back to that later. But my opinion as a former judge of the African Court would be to say, yes, the right of self-determination of peoples integrated within the state can be exercised, but only within the borders, within the state itself, in order to avoid the explosion, because it's a Pandora box in a way. And this was the opinion of the African Commission of Human and People's Rights based in Banjul. When one case came to the African Commission, it was about Katanga. And the African Commission said, yes, right of people to self-determination, it's enshrined in the African Charter, but it has to be exercised within the borders of the state concerned. Democratic Republic of the Congo at that time. So this is a very interesting question, and we'll come back later. I will come back to that next session or the other one, or both, in both sessions actually. Thank you very much for your questions. Thank you for your comments and questions.